I think if you're a global brand, to be perfectly honest, even if you've read the book, it's impossible to be compliant in each and every country around the globe. So what we generally do is we sit down with the client and work out which territories are key, and that might be for some clients 5 or 6, or in some cases 25, 30. So I think once you've worked out the territories that are key to you and your business and your promotion, then I think it's a matter of issue spotting, so i.e. having a think about the mechanic or the creative you're using, and then thinking about the legal issues that surround that. And that's really what we've tried to do in the book, is tease out those key issues, and hopefully they serve as a useful aid memoir before you then go and get local advice. Specifically, we deal with gaming, pharmaceuticals, financial services, and things like tobacco. And I think bleeding out of tobacco, I think something really interesting is happening with e-cigarettes, something that we're doing a lot of work on at the moment. And I think the UK in particular is leading the way in terms of bespoke rules and regulation around e-cigarettes. But I'd say, to answer your question, that is a sector of particular interest to us, and we describe it as a bit of a moving target at the moment, where the law is wrestling with the existing rules and regulations and trying to keep up. One of the areas that is particularly popular is running a global prize competition or sales promotion. And I think for readers it becomes quite striking to see that even in Europe, where there's supposed to be a degree of harmonisation, there are very discrete, bespoke rules, whether it be lodging a bond in certain countries or registering formally, myriad of issues. So agreeing a standard set of terms and conditions on a European or even a global basis, I think can be quite difficult, and I think that certainly comes out when readers particularly look at the sales promotion section within the book. Whenever you have new technology, there are new challenges for practitioners. I think when it comes to smartphones, tablets, PDAs, that sort of thing, I think the rules and the laws are in place, but it's how the practitioners stretch those rules and use those rules to find the answers. I think there are some real challenges, particularly on the privacy side, when it comes to tablets and smartphones, and some quite exciting things coming through that others may call a bit Big Brother, in terms of tracking individuals and looking at their buying patterns, which means that as practitioners we have to look very closely at data protection and privacy matters. We had a lot of fun working during the 2012 Games. We were very fortunate here in our practice that we were acting for a number of lead official sponsors, but also we were acting for smaller advertising agencies and brands that really wanted to make full use of what we described as a festival of sport. So very, very interesting. Of course, in the UK, we were operating under some pretty strict legislation that was again there to protect the interests of lead sponsors. So we ourselves found ourselves often speaking to the media in terms of protecting the position of the key sponsors, which in short was really to protect their massive investment. I mean, as viewers and readers of the book will appreciate, they were committing tens of millions of pounds to have the benefit of being an official sponsor, and in exchange for that they wanted to ring fence their interest and exclusivity. So we were heavily involved in that, and it was a fascinating project, and has now given us a real reference point in terms of other tournaments, including the World Cup that's going on now in Brazil. I think with the benefit of hindsight, I think they did a good job in terms of in the lead up to the Games, i.e. during the torch relay and other practice events. I think they, in a pragmatic manner, went around, pointed out the requirements under the legislation without bringing any criminal prosecutions. And therefore, by the time the Games came around, I think there'd been so much in the media and press that it almost took care of itself, which meant that we could enjoy the Games themselves rather than having to follow court actions around the legislation. Well, it depends what your definition of ambush marketing is and whether it's lawful or unlawful. When you look at an organisation like Nike, I think they're putting out some of the very best advertising. And what they do is they often trade on the reputation of the footballers that they have under contract. So even by the time they arrive at the tournament, everybody wants to follow their role models and the players that play for their teams. And so they don't need to reference the World Cup or Brazil or anything like it. We all know they're playing in the tournament, and they are really trading on the reputation of the players themselves, and they do that in a very creative way. So they're clearly the right side of the line because they're just making the very most of these massive personalities and reputations, but nobody watching it necessarily would feel that they are an official sponsor in the way that Adidas is. It can be very difficult. Of course, when we had London 2012, there was bespoke legislation which made it quite easy for LOCOG, in that particular case, to bring action. It's interesting that even in that case, brands themselves didn't have a direct cause of action, certainly not an obvious one. So when you're dealing with countries that don't have that specialist legislation to try and restrict ambush marketing, again, it's really reliance on established IP rights, which, again, here in the UK, quite often you'll see brands trying to rely on the tort of passing off, which is where an advertiser, if they're not official, is trying to misrepresent their association in some way, which can serve to damage, even financially, the interests of an official sponsor. And again, around the world, there are similar principles in terms of unfair competition, where they're taking advantage of key sponsors and a tournament and an event. So again, it's reliance on established IP rights. Controversy, to be perfectly honest, is often the oxygen of advertising. And so it depends on your brand values in terms of whether you really want to do a shock and awe type campaign, or you want to be perceived by your customer base as a bit more conservative. In terms of controversial, a few things I guess spring to mind. Those that are old enough may recall the Benetton campaign, which often used a number of shocking images. There's also more recently Paddy Power ran a campaign that involved taking bets on the Oscar Pistorius trial, which again caused a great deal of controversy in the marketplace. But again, I come back to the first point. Depending on where you are and where your brand is, any publicity might be good publicity. So again, as practitioners, we often have to weigh up the commercial drivers for certain campaigns. We can provide the legal framework, but often there might be somebody within the brand that actually thinks it's worth getting the attention, no matter how controversial the campaign might be. The team here at Bristow are very proud of the finished product. We certainly enjoyed working with some of the lead practitioners around the world. It's always a nice excuse to hook in with them and see what's going on within their own jurisdiction. I think predominantly, particularly if you're a global brand or if you're a practitioner that's looking outside your own jurisdiction, I feel it's a really good, accessible, ready reckoner to, again, understand the key issues that might be going on as part of a campaign or a competition. I think as I sit here now, I have to say it won't have all the answers, but I'm really confident in terms of it having the key issues, which will then enable practitioners to drill down in local markets if they see fit.